Good morning, everyone. Welcome to our webinar on employment law, our employment law update for the first few months of 2020. Now, just to give you a quick rundown of what we're going to be talking about today, it won't be furlough. And I appreciate that furlough is on everyone's lips at the moment, and it's the main issue that we all have, but we won't be touching on furlough at all today. So it will just be your normal case law and legislative update that we'll be covering. Now, I particularly enjoy these webinars now because it's the first time of the week where I get to wear an iron shirt now. And I hope that you're all dealing with lockdown all right. And certainly better than the picture that I saw on Twitter today of the person who was giving themselves their lockdown haircut with their clippers, and their clippers then died halfway through the haircut, which led to a rather unfortunate sight. So this is the first of a series of webinars that we're going to be running. We are going to be also running a webinar next week on post-termination restrictions. So if you're interested in that, then it was on one of the original links that went around, but I will also send around an update link also by email in due course, and also posted on LinkedIn. And then when we go into May, which is only of course a couple of weeks away now, but when we go into May, I'll also be doing some webinars on key points of disability discrimination, and also settlement agreements and without prejudice conversations in section 1A protected conversations as well, and how we go about doing those and how it's best to do that. So that's the plan for the next few weeks in terms of these webinars. This one will last from 10 o'clock till 11:15. If you do have any questions, then please do click on the Q&A box, which should be somewhere towards the top of your screen. I see a slightly different screen, so I'm not actually sure quite where it is on yours, but please just click on the Q&A button and you can ask questions as we go through. It would be helpful actually if you put your email address on the question that you send through. Don't worry, no one else will see it, but if you do put your email address, then it does mean that if I don't get to answer it during the course of the webinar itself, then I can follow up with an email to you later. And also, what I intend to do is, if you have entered in your email address as you've entered into this webinar session, then I'll send you all of the materials afterwards as well. Okay, so I'll just do all of that all automatically. Okay, so that's the plan for this morning. Now, in terms of what has happened, which isn't furlough. So as you can see, we've got a couple of areas that we're going to be having a look at. So in terms of legislation, as you can see, we're going to be having a look at parental bereavement leave, agency workers, contracts of employment holiday pay, the Information Commissioner's Office's guidance on data subject access requests, and also IR35. Now, in terms of case law, which there's probably a bit more to talk about in the case law section. So we're looking at PCPs, and obviously that's to do with provision, criteria and practices, not anything else. Whistleblowing, unfair dismissal, shared parental leave and pay, veganism, and vicarious liability and data protection. So that is the plan for the next hour or so. So I hope something there is tickling your fancy. And I know I said that we weren't going to be having a look at furlough, but this is just a reminder. The scheme is now open. I'm sure you've seen it all plastered over the news during the course of yesterday, but the portal for all the furlough applications, the job retention scheme applications, is now open. So if you have got staff that you have furloughed, then now is the time. And we are being assured by the government that actually they're going to be turning these around fairly quickly. So you should be able to, if you make your claim promptly, you should still be able to get the money from the scheme in time for the April payroll. So that is all good news, albeit that of course we've had another set of guidance that was issued on Friday evening, and also some more detail about how you actually calculate the payments that you're going to be recovering. Obviously, any questions, then please give me a shout. So without further ado, we'll go into the case law update first. As I said, the case law update is probably slightly more, got slightly more to it than the legislative update, but don't worry, there's still some important things in the legislative update. I don't want to downplay the importance of that section. Now, so in terms of our first case, so it's the Ishola case and Transport for London, and it deals particularly with this issue of a provision, criteria and practice. And what we're looking at here is the issue of reasonable adjustments. Okay, so just to in terms of the facts of this case, this involved a lady who was a customer service, sorry, not a lady, it was a man, customer service administrator who brought a grievance about the conduct of another employee towards him. He was unsatisfied with that grievance and also the investigation that went with it, and he went on sick leave. Now, then whilst he was on sick leave and shortly before his dismissal, which then took place 13 months after he went on absence as a result of his medical incapability, he raised other grievances. And he then brought his employment tribunal claim. Obviously, his employment tribunal claim dealt with unfair dismissal and various issues of reasonable adjustments. And what we're going to be focusing in on here is the alleged failure to make reasonable adjustments and this whole issue of PCPs, because PCPs is a very, although it's quite a legal term, and I'll turn to it when we get to the end of dealing with this case about how you actually deal with this in practice and what the importance of PCPs are. But in terms of what the PCP actually is, so what we're dealing with here is where somebody is where there's a duty to make a reasonable adjustment. The PCP is where we've got a situation, it's a practice, it's a provision of obviously a criteria that puts an employee at a substantial disadvantage in comparison with those who aren't disabled. So therefore, if you are then in that situation, so you've got that individual who is being substantially disadvantaged in comparison to those who aren't disabled because of the practices that you apply, it's at that point steps as necessary to alleviate that disadvantage, which of course is the reasonable adjustment. Now, what we're looking at here is whether, of course, there is an obligation to make a reasonable adjustment where there's a one-off act. Can a one-off act constitute a PCP? Now, the act in question here was the alleged failure to deal with his final two grievances. So there were other claims in relation to reasonable adjustments which were successful, and this is quite useful in terms of being able to have make some sort of assessment as to whether in fact this is a provision, criteria or practice that's occurring. So is it a general state of affairs that is putting the individual at a disadvantage or not? So there were two aspects, two reasonable adjustment claims in this case that were upheld, and they were in relation to the lateness on the part of the employer to advise him about his reduction in sick pay. So quite clearly there was a practice that they would advise employees within a set period of time, albeit that that wasn't very quick, and so therefore there was a delay. So other people were affected. And also the failure to allow a friend or a family member to accompany him at his sickness review meetings. And again, you could see that that would be a practice because, of course, the company was, for all intents and purposes, just applying their policy, which is to allow work colleagues or trade union reps to accompany them. But when we have a look at the final grievance issue, was the failure of the Transport for London to deal with his grievance in the way that he wanted them dealt with, was that a one-off act or a decision, or was it a provision, criteria or practice? So what the courts have said is that actually for it to be capable of being a PCP, then it's got to be something that isn't just a one-off act. Now, this is quite helpful, of course, for employers, because it reasserts the position that we'd sort of understood anyway, as you can see in those relevant cases that I put at the bottom, if you particularly want to go off and read a few more examples of the situations where things are or are not PCPs. But you see, what it does is it enables us from a legal point of view to then have an argument in relation to reasonable adjustments, to be able to defend your position in terms of reasonable adjustments if in fact it's a one-off failure. So if, say, for example, it's not necessarily that the policy itself is in any way disadvantaging someone, it's just simply the fact that you messed up in applying that policy on a one-off occasion, then that's not going to be a failure to make reasonable adjustments. Now, that doesn't mean that you've got carte blanche when it comes to one-off acts, because of course there are still other claims that can be brought in terms of direct discrimination claims or discrimination arising from disability claims. So you still need to be careful. But in terms of what this means for us in practice, so what are the takeaways from this? Because that's quite a sort of legalistic point that is being made from there. But I think it's quite important that whenever you are in a situation when you are looking at a disabled employee who believes that they are put at a disadvantage, and you're looking at what reasonable adjustments need to be made, potentially, then one of the things that you should be doing is sort of going through the step process, so going right back to the beginning, which is, so what is the situation that is placing this individual at a disadvantage? Quite often, when you're looking at reasonable adjustments, you'll be faced with essentially a prompt from the employee saying, or the employer's advisor or medical advisor, occupational health, who are saying, this is what you need to do. This is the adjustment you need to make. So it all gets focused on the adjustment. But what you need to do is go back to the beginning. So you need to go back to what is the actual situation that is causing the disadvantage. And then, is there causation between that situation and their disability? So does the individual's health, does their disability actually cause the disadvantage from that situation? And then it's only once you've answered those two questions that you then go into having a look at what steps you can take to alleviate that disadvantage, and of course whether it's reasonable to do so. So in terms of the takeaways from this, it's really just a case of, from my point of view, it's reasserting the questions that you need to ask yourself whenever you're having a look at situations about disabled employees managing ill health and managing potential adjustments to their job or their working environment. Okay, so that's the first case, so Ishola. Now, the second case that we're looking at today, so this is protected disclosures, so it's whistleblowing. Now, whistleblowing is an area of law that is becoming increasingly used. Of course, one of the advantages to claimants using this whistleblowing legislation is that you don't need 2 years service to bring a claim under the whistleblowing legislation. So in that ways, it's very similar to discrimination. It also doesn't have the cap in compensation of 1 year's gross salary or the circa £85,000 unfair dismissal cap. So you don't get the cap in compensation. And also there's a potential to access injury to feelings claims. So it's very much looks like and sounds like discrimination claims. So where there aren't protected characteristics that someone can potentially use, then often whistleblowing is something that is a route that people will go down. Now, the facts of this case are that this involves as you can probably tell from the respondent's name, it involves an NHS trust. So we've got a consultant surgeon who is highly critical of trust management and also consultant colleagues. And as you can see in those 5 years, 2009 to 2014, makes a series of allegations to the trust and also to regulatory bodies and to third parties, including the media. Allegations included serious professional incompetence, improper medical practices, so on and so forth. You can read them there. But also includes attempts to cover up and also to gag him. Now, I won't get into the detail of what claims were brought necessarily, but essentially claims were brought in the High Court. He then inappropriately disclosed some information to the media during that High Court action, which then prompted a compromise agreement, which also settled an employment tribunal claim, which he'd also issued. So that's settled. Up until that point, that compromise agreement then settled all potential claims. But then what happened was that after that compromise agreement, he then alleged that there were post-compromise agreement detriments. So this is being subject to a detriment because he had made these disclosures. And the detriment that he'd argued, which I'll get onto in a moment, it was essentially to do with the response by the employer in relation to the allegations that he'd made. But first of all, let's just have a quick look at what protected disclosures are, and in terms of who you can disclose to. So, first of all, in terms of going back to the fundamentals of protected disclosures. So, protected disclosures. So that's Section 43A of the Employment Relations Act. And where you are disclosing a criminal offence or a legal obligation, health and safety matters, matters in relation to the environment, or a miscarriage of justice, and where making that disclosure is in the public interest to do so, then you can make the disclosure if you reasonably believe it to be true. So it doesn't actually have to be true, you just reasonably have to believe that it's true. And in those instances, you are then protected from any detriment, or dismissal obviously, from having made those disclosures. Now, there are then some further rules that's covered by Section 43G. Now, in terms of what Section 43G says, is that it's all about who you're entitled to make those disclosures to. So you're entitled to make those disclosures to someone within your organisation or a prescribed person, which is normally a regulatory body. But there is also then a catch-all which then says to other persons, which is hence the title of the slide, whistleblowing other persons. So in what circumstances are you then entitled to make a disclosure outside the organisation and outside the regulatory body? So as you can see here, Mr. Juza, I've got the, sorry, I'm having difficulty pronouncing, JZUDDIN. You can see his Twitter page there, and so lots of tweets that he has sent and lots of potential disclosures being made. As you can see, he describes himself as surgeon, researcher and whistleblower. But as you see here, the disclosure outside the organisation and outside the regulatory body should be a last resort. So where it is not adequate or appropriate to disclose to the employer. And of course, where we see the sort of growth in the use of whistleblowing, we're probably going to see the growth of people making disclosures outside the organisation as well. Often we have threats of people going to the press and so on and so forth. So when we then look at in practice, when it is reasonable to make the disclosure outside of the employment tribunal, one of the things, well, first of all, it's just simply a question of fact for the ET as to whether it's reasonable or not. So they will take into account all of the surrounding circumstances. So to what extent has the employer dealt with disclosures that have been made to it in the past? What has been the reaction for disclosures in relation to those that have been made to it in the past, and so on and so forth. Now, in this instance, what the claimant was doing was saying, well, he's made disclosures to the regulatory bodies and also to the trust before, and they've just said that, you know, they've just denied them. And so therefore it's on that basis that he felt he needed to go outside of those organisations. But what you can't do is you can't use it to gain protection for a whole host of complaints unjustifiably brought, just simply on the basis that one of them is reasonable. So the way that the decision that the individual has to make is quite stark in that they've got to be very, very clear that they only make they only disclose information in relation to those issues that are reasonable for them to do so. So they can't just throw a lot of mud and hope that one of them sticks. They've got to be far more targeted and specific than that. And the whistleblower has got to take responsibility for the way that the complaints are framed. So how is it that those complaints are being positioned? So irresponsible disclosures are not protected. Now, that then turns us to the last point on this slide, which is in terms of the respondent's rebuttal. So this effectively was the detriment that he was claiming about. So when he made these disclosures, there was an incredibly strong rebuttal from the employer. And because that rebuttal was so strong and very critical of the claimant, it's on that basis that he claimed that it was a detriment. So the courts then did look at the extent to which a respondent can rebut disclosures that are made, allegations that are made under the Protected Disclosure Act. And what the tribunal said was that, yes, you are entitled to respond robustly where it is appropriate to do so. But you mustn't make misleading statements about the individual or about the way that they made their disclosures, because if you do that, then that could lead to a detriment. So we've got, essentially they're just taking a very balanced approach here, which is, yes, of course, if you've got a justification for setting out a very strong rebuttal, then you can do so. And where it's important for you to do so, particularly, say, for example, where you are regulated and you've got allegations that are being made which would damage your business, then you will need to make a rebuttal. You will need to be seen to be making a rebuttal. And you can do so robustly where appropriate to do so. So that's good news for employers. So just taking, again, the important points. So employees and, of course, workers. We're not just looking at protection for employees here. So they are restricted from unreasonably making disclosures outside of the organisation or regulatory body. You're entitled to robustly respond, but be cautious when doing so. Make sure that any robust rebuttal is balanced in the appropriate way, and that you have justification for a strong rebuttal. So if there is damaging information in the public domain, which requires a strong response, then you'll be more justified for making that strong, robust rebuttal. In circumstances where there isn't that damaging information in the public domain, then the reasonableness of a strong rebuttal is going to be questionable. Okay, so that's whistleblowing and also PCP. So let's get on to some good old-fashioned unfair dismissal, gross misconduct dismissal, and some rather unfortunate or rather salacious facts in this one. I haven't put all of the detail in here, but I'm sure you can probably get a feel for what sort of case this is when I start going through the facts. So we've got the good old-fashioned Friday night out drinking with colleagues, and then an incident occurs between the claimant and a younger, more junior female employee when they were seen entering into a disabled toilet in the pub. Other colleagues then went to intervene because they were concerned for the safety of their female colleague. So that's incident number one. We then got incident number two, which involves a conversation which took place between those same two individuals on Monday when they returned to work. The content of this conversation was also disputed. So we've got disputed facts. And also we've got two people who really can't remember what's going on here as well. So the female employee made a complaint of sexual harassment. She accepted that her recollection of the not so much perhaps that her recollection of the evening was rather murky, but actually that she accepted that she was the worse for wear that evening. And the male employee simply could not remember what had occurred. She also made a complaint to the police, but This was later withdrawn, and the sort of timeline of events here is quite important, because the employer, of course, starts an investigation, and starts an investigation on the basis of it being a potential gross misconduct dismissal. She makes her complaint to the police, but shortly after the conclusion of the investigation by the employer, she is then shown CCTV footage by the police, and on the basis of that, having viewed that CCTV footage, she then withdraws her complaint to the police because she accepts that there is a distinct possibility that actually that she went to the toilet first, or in fact there was clear evidence that she went to the toilet first, and that the male colleague was actually coming along to potentially try to provide her with help and assistance rather than it being anything else. Now, moving on to the dismissal. Now, the dismissal did take place. So the dismissing officer was unaware of the withdrawal of the complaint to the police, but the investigating manager was aware of that withdrawal. The dismissing officer continued to dismiss for gross misconduct. So then we get down to the issue of, right, okay, so was the dismissal fair on the basis of what the dismissing manager knew at the time? Or to what extent is the employer liable for information that it knew, even though that information was known by somebody else in the organisation rather than the dismissing manager? As you can see here, and this sort of shows the uncertainty that you always have in gross misconduct and unfair dismissal cases, or in fact employment tribunals generally, because you can see they went along to the employment tribunal and the employment tribunal found that it was a fair dismissal. However, there was an appeal, goes to the employment appeal tribunal, and they overturned the decision, and they found that the dismissal was in fact unfair. And what was concluded by the employment appeal tribunal was that the question of the knowledge of another person in the organisation, rather than just being focused on the knowledge of the individual who dismissed, can also be relevant to the fairness of dismissal. So where somebody who had had responsibility for the investigation does not share a material fact with the decision maker, then that goes to the heart of the fairness and reasonableness of the dismissal. I mean, to be honest, it's it seems fairly obvious, doesn't it? And certainly when we go back to other case law in relation to, say, for example, absence dismissals, where occupational health and or HR know of the disability of that individual, but perhaps the line manager hasn't been told, and then the line manager is the one that's pressing forward with a dismissal, and so doesn't know about the potential reasonable adjustments that might need to be made because he or she hasn't been privy to the detailed information about somebody's medical condition. But where the employer has the information, then that knowledge is imputed into the decision maker. So it's expected that you should ensure that you've got systems in place to make sure that the person who is making the decision has all of the relevant facts and has all of the relevant evidence. And in this case, this is clearly potential relevant evidence that she has withdrawn the complaint to the police. Now, it doesn't necessarily mean that then the dismissal might not still have been fair if in fact the decision maker then concludes that even though that the complaint to the police was withdrawn, he or she could still potentially conclude that an act of gross misconduct occurred. Obviously, it would require some further exploration by the dismissing manager disciplinary hearing manager, I should say, in order to be able to get to the bottom of that. And this is also this whole principle about knowledge of the organisation needing to be known by the decision maker is also underlined in the recent case of Duty and the Royal Mail, which, as you can see, went all the way to the Supreme Court. And in that case, it was sort of played the other way around. So this wasn't the investigating manager. This is where somebody higher in the organisation who has determined that somebody should be dismissed for a particular reason, but hides the inventive reason that the decision maker adopts, so sort of hiding behind the decision maker who didn't know of the real reason, that still can be an unfair dismissal, because the reason for the dismissal is the hidden reason rather than the invented reason. Okay, so we've got to be really very careful that the decision makers, when they're sat down and making these decisions about whether to continue to employ people or not, that they have all of the relevant information. So even after, particularly where there are delays between the conclusion of the investigation and also the disciplinary hearing taking place, that there is a double checking process that then takes place before you then move on to decision or moving on to the disciplinary hearing, to make sure that you've got everything that you need to have. Okay, so this is quite a quick one. It's an update. For anyone that has been attending our legal updates that we've been delivering over the last couple of years, of course, those have all been done in person, whereas this one is a webinar. So I'm hoping that we will be able to have more people attending these webinars than of course the normal restrictions that we get when we're having to do them in person and all of the travelling that everyone has. But you may have read about this anyway. So this is the HEXTALL and Chief Constable of Leicestershire Police. It's the whole issue of shared parental leave and pay. And of course, the whole issue of shared parental leave and pay, or should I say parental leave pay, is to do with whether there is any obligation, whether it's discriminatory, to not enhance shared parental leave pay in the same way that employers also enhance maternity pay. So say, for example, I mean, both in the HEXTALL case and also you'll see on the second bullet point, the case of Ali and Capita being referred to there, that in both those cases, the employer had an enhanced maternity pay scheme, but then paid shared parental leave simply at the statutory rate of pay. And so we had these two men who brought claims under sex discrimination, saying that, well, this is sex discrimination. I'm taking very similar leave to the women who are taking maternity leave, and the purpose of it is, they argued, the same, but I'm only getting statutory pay rather than the enhanced pay. So they argued that that was discriminatory. And both those cases managed to work their way through to the courts of appeal, and both failed for different reasons. One was a direct discrimination claim, one was an indirect discrimination claim. Now, there was an application in the HEXTALL and Chief Constable of Leicestershire Police case to proceed to the Supreme Court, to appeal to the Supreme Court, but that has been refused permission. So that decision now stands and will not go any further. It's also been confirmed that there's no live appeal in the Ali versus Capita case, so no application was made in that case. So the decisions that were made in both those cases now stand, and so therefore there is no requirement on employers to enhance shared parental leave pay to the same level as maternity pay. Veganism. Now, this was one that was reported probably about 3 months ago now. It was just in the new year, so when things were very different to as they are now. And it's whether veganism was a protected characteristic under the religion and belief. Now, as you can see, that this chap, CASAMITJANA, Mr. CASAMITJANA, was a qualified zoologist and dedicates his life to helping animals. He became vegan in 2000, sorry, not in 200. So he became a vegan in 2000. His diet and clothing all avoid animal products. He's considered to be an ethical vegan rather than simply a dietary vegan. Now, of course, the whole issue of veganism, and we had veganery in January as well, and so we've got there's a lot more vegan people out there than there was before. But what we're looking at here is someone who is really quite different to someone who's simply making a dietary choice in relation to veganism. They are making an ethical choice, and they're referred to as an ethical vegan. As you can see here, he participates in animal protection marches, demonstrations and protests, gives speeches at the events, and is vocal about his support for the ethical vegan lifestyle. He doesn't wear any clothing in relation to animal products, and in fact, one of the other things that he mentioned in his witness statement in relation to the extent that he lives his life in this way was the fact that if he has to travel, he will avoid trying to travel by public transport because of the effect that will have on flies and insects that will get killed as a result of that vehicle. So, as I said, it's not just about diet. These are ethical vegans are people who have chosen to live as far as possible without the use of any animal products whatsoever. And something that I learned from having a look at this case is that the concept of veganism is rooted in the ancient concept of ahimsa, which is one of the main premises of the ancient Indian religions. And so ethical vegans are moralistically orientated and opposed to all exploitation of animals. Now, so this then, when we're having a look at what's got to be met in relation to religion and belief, because this is where we're looking at in terms of the way that the law might protect someone. So it's a belief that's got to be genuinely held. It's not just an opinion or a viewpoint. It's got to be, and this is particularly relevant, this next bullet point is particularly relevant in relation to making the distinction between ethical vegans and just somebody who is a vegan for dietary purposes. It's got to be weighty and substantial aspect of human life and behaviour, and a cogency, a seriousness, a cohesion and importance. And so, as you can see from the level of belief that Mr. CASAMITJANA had in relation to his veganism and his ethical veganism, he quite clearly met the requirements for religion and belief discrimination, for that being for him being protected under the Equality Act. There's really not much more to say about that case. It's simply the case that it was reported as vegans being protected under religion and belief discrimination, but as you can see that there's quite a significant difference between someone like Mr. CASAMITJANA and ethical veganism and just someone being a vegan generally. Now, we are now moving on to, again, another one which you've probably read about, and this is about data protection. Now, I know that data protection might not be the most exciting subject in the world, but this is all about the employer's vicarious liability for data breaches, which is obviously with the increased focus that there is on data protection generally, not just because of GDPR and the associated guidances that go with that and the reviews that everyone has had to undertake in relation to privacy statements and all your policies and the way that you deal with data. But this is also about the use of data, the access that people have to data, and the potential breaches. Now, this case, I mean, it actually predated GDPR, but Mr. Skelton was a very disgruntled employee. He had a grievance that wasn't upheld, and in fact, he was given a disciplinary warning for something. And as a result of that, he was unhappy. Now, as part of his job, he had access to employee data, which included bank records. And because he got given this warning, because his grievance wasn't upheld, he decided that he would leak that data of more than 100,000 employees onto a file sharing website. He was, obviously they caught him doing this, he was convicted for this and he was sent to prison. But then what happened was that then there were claims that were then brought against Morrison's by nearly 9,000 employees who had had their bank details shared on this website and had suffered financial loss as a result of the sharing of those details. They then brought claims against Morrison's for their losses. Of course, you know, there's probably little point bringing claims against Mr. Skelton because he won't be able to pay them. So then it all comes down to, well, to what extent are Morrisons vicariously liable for the acts of one of their employees? Now, originally, Morrisons were found liable. So as you can see here, the High Court and Court of Appeal outcomes were that they were liable. And so this was very worrying for employers. This was quite concerning because clearly Mr. Skelton went off on a, what they generally refer to as a frolic of his own. He wasn't authorised to do this. In fact, he was dismissed for doing so. And so how can an employer be held responsible when somebody goes off and does something that they are not authorised to do so? But what the law says is that you can still be vicariously liable if there is a close connection between those wrongful acts and the acts that they are authorised to do so. Now, the previous courts have decided that because he had access to this data, because he had authorised access to the data, the connection was close enough. But what the Supreme Court said was just simply no, that whilst he had access to that data and was authorised to have access to that data, his acts in themselves were as far removed as being authorised as is possible, and that the High Court and Court of Appeal decisions were just plainly wrong, and so the case was dismissed. Now, this is, of course, a welcome decision for employers, because it does mean that actually you're just simply not going to be held liable where somebody is going off on an unlawful frolic of their own like this, and that's quite right. Just to give you another case. That, again, this is quite recent as well, just dealing with vicarious liability. This obviously isn't to do with a data breach, as the slide suggests. This is to do with sexual assaults between 1968 and 1984 by a doctor that was employed by Gordon, but it's not employed, sorry, engaged by Barclays Bank, Dr. Bates, who sexually assaulted people who were then sent to him for medical assessments. And again, that was said that there wasn't a close enough connection between what he was authorised to do and what in fact he did do, so the bank couldn't be held liable. So again, a good decision for employers, and I think quite rightly so. So that concludes the case law update. If you do have any questions about any of those cases, then obviously please fire them in. I can see that I've had just an inquiry as to whether we will be doing another webinar on furlough soon. Haven't got one planned in at the moment, but we'll certainly be looking at doing one towards the end of this week or possibly the beginning of next week. We just need to do a quick review of the guidance that was issued on Friday night in order to assess what changes have come from that. Although what I will say, I know I did say that I wouldn't be talking about furlough, but what the recent guidance from Friday does indicate quite strongly is that someone can take annual leave whilst they are on furlough without interrupting the 3-week period for furlough. So that's one useful bit. That's not absolutely 100% nailed down, because that point is actually set out in the employee's guidance that says that you can take holiday. And so it's not absolutely clear that the employer can require an employee to take holiday, say for example Good Friday and Easter Monday during the furlough period. But I think that's probably splitting hairs. My view on that is that is okay. So turning to the legislation update. Now, as I said at the beginning, there's not quite so much here as would sometimes be the case. Now, one of the main pieces of legislation that's come through is the parental bereavement leave. Now, this applies from the 6th of April 2020, so just a couple of weeks ago now, and it provides employees with the right to take 1 or 2 weeks off work following the death of a child under the age of 18. Now, this, according to the statistics, this will affect 1 in 4,000 employees every year. So you can do the statistical likelihood of you having to deal with this, but but it's obviously something that is very much welcome and means that it is giving a proper legislative footing to compassionate leave in these circumstances. Just to be clear, the leave can be taken at 2 separate weeks. So it's not like paternity leave where you take it in a block of 1 week or you take it in a block of 2 weeks and that's it. With paternity leave, once you've taken your 1 week, you can't then take the other week at a separate point. With parental bereavement leave, you can do so. It does include stillbirths after 24 weeks of pregnancy, and it is for employees only. So, and there's no service requirement in relation to the leave aspect at all. There is a service requirement in relation to pay, which is triggered slightly separately. But in terms of the entitlement to leave, no service requirement. It's a day one right. In terms of those people who can take it, obviously, as I said, it's for employees, but it also will apply to obviously the child's parent, but that includes adopted parents, a prospective adopter, an intended parent under a surrogacy arrangement, and also a parent in fact. And now when we say parent in fact, what we mean by that is someone who has been looking after that child in fact, but is not actually their parent. Or of course, if for someone who isn't the child's parent, sorry, I'm falling over myself a little bit here, it's all rather complicated. There's a big long bulleted list, but also that person's partner. So if you are the partner of the parent, but you're not actually the parent, you're the blood parent of that child, you can still take this leave. Doesn't cover paid carers. And it can be used at any time in the first 56 weeks after death or stillbirth. Now, the reason for that is because of the tying in with maternity leave as well, which I'll get onto. But essentially what that means is that if somebody has, for example, a stillbirth or alternatively a baby dies shortly after birth, then the woman is still obviously entitled to their maternity leave of 52 weeks. And what they can do is they can then use the parental bereavement leave at the end of that maternity leave period. So that's why there is this 56 weeks window of opportunity to take this leave. Now, notification, right, during the first 8 weeks after the bereavement, the employee need only give notice on the first day of leave. And that doesn't need to be written notice, it can simply be telephoning to let the employer know. However, once we get from weeks 9 to 56, you've got to give at least 1 week's notice, and also can be rearranged or cancelled with the same period of notice. So as you can see here, it's a very flexible notification requirement, which is unsurprising given the circumstances from which this leave arises from. And as with all other statutory rights, there is, of course, a protection against detriment or dismissal for asserting that statutory right. So in the same way where we were looking at whistleblowing legislation a little bit earlier, when we were looking at that case, the claim that was brought in the whistleblowing case was about the detriment that they suffered as a result of having blown the whistle. These individuals are also, these employees are also protected against any detriment for asserting or attempting to assert their statutory right to bereavement leave. Now moving on to pay. So as I said, the requirements with pay are just a little bit different. You must have 6 months continuous service to qualify for pay. You must have weekly earnings that are above the lower earnings limit, which for the tax year of 2020 and 2021 is £120 a week. And then as long as those two conditions are met, then it is paid at the same rate as statutory paternity pay and shared parental pay, which as of this tax year, so as of 6th of April, is £151.20, or 90% of your average weekly earnings if it is lower. And as I said, it's 1 to 2 weeks pay, so it mirrors the entitlement to to leave. Now, in terms of the entitlement to the pay, statutory sick pay overrides parental bereavement leave pay, and the other two circumstances which also prevent somebody from getting paid for parental bereavement leave is obviously if the employee dies, which hopefully would not happen, but also if you're detained in custody or sent to prison, you also aren't entitled to pay. So quite interesting, the two particular exemptions that they've given there. One other point just to clarify, in terms of the right to return to work and what job you have the right to return to, you have the right to return to your previous job unless you have added it onto any other form of leave, such as paternity or parental leave or maternity pay. Sorry, not maternity pay. If you've added it onto parental leave of more than 4 weeks, then you have the right to return to the same job, or if that isn't reasonably practicable, a suitable alternative. If the bereavement leave is added on to another period of statutory leave, such as maternity or adoption leave, and that period of leave has been for 26 weeks or more, then again, it's the same job unless that isn't reasonably practicable, and then it's a suitable alternative position. Okay, but most of the time I would normally expect people just to simply return to their normal job. There is some government guidance. There's the link for it. It was published on the 8th of April. It's quite helpful, so feel free to have a look at that as well. But obviously, if you need any help or assistance with this, any template policy, then please get in touch and we can let you have that. Now, agency workers. This, again, for those of you casting your minds back, we've had the Good Work Review by the Taylor Report. Now, what that looked at was essentially the whole gig economy issue and rights for 0 hours workers and self-employed, etc., etc. Now, one of the changes that have come about from that is to provide some greater protection for agency workers. So as of the 6th of April of this year, so a couple of weeks ago, the Swedish derogation has been removed from the agency workers regulation. Now, for those of you who aren't aware of what the Swedish derogation is, essentially it was a loophole in the agency workers that allowed the end user and also the agency to avoid the obligation, the 12-week obligation in the agency workers regulations to equalise pay. And that could be done by ensuring that the agency actually employed the agency workers. So they would be employed by the agency, and as a result of being employed by the agency, that then provided this Swedish derogation. Now, an awful lot of agencies, most agencies didn't employ their workers in any event. They simply supplied them onto the end user, and then when the end user ceased using them, then they might have a look for alternative work for them, but there was no obligation. They weren't employing them. Some agencies went a step further and actually did employ their agency workers and therefore could take advantage of the Swedish derogation. Clearly, as part of providing protection to agency workers, that didn't provide them with protection. It completely sidestepped the agency workers regulation, so therefore that has now been removed. It's one of the recommendations. And a further change is that any agency, any temporary work agency, so I don't know whether we have any temporary work agencies who are sitting in on this webinar, but if you are, then by the 30th of April, you have got to provide a notice to any agency worker that you have who you are using a Swedish derogation for, that you write to them and confirm that those provisions will now no longer apply. Contracts of employment, the written statements of terms and conditions, commonly referred to as the Section 1 statement, have been changed. So those regulations, these regulations require now that rather than that statement, that main written statement of terms and conditions being given to someone within their first 2 months of employment, that has now got to be provided on the first day of employment, and also applies to workers as well as employees. So that's the first change. The second change is that it's also requiring a bit more information to be given, but it is setting out that you can provide that in different documents. So there are some particulars of in the contract that must be contained in a single document at the beginning, some that can be contained in a reasonably accessible document, and some other particulars that might be or can be given in instalments no later than 2 months after the start of employment. As you can see there, I haven't listed them all out. I can provide them in or I will provide them in the pack that will be emailed to you at the end of the session, because it's just a little bit too much detail to be going through now and here. But in terms of the new additional information that's required in order for you to have a compliant Section 1 written statement of main terms and conditions, and I would imagine that a lot of you have got this in your contracts already, so there's going to be very little change, I would expect, for the majority of you, but you should be including the working schedule, so what days of the week people have to work, whether the hours are variable, and how any variation will be determined. What paid leave is available, all types of paid leave, obviously detail of remuneration and benefits, whether there is a probationary period. But this is the new one which almost nobody had in their contracts before, but it's this, you've got to state whether there is any entitlement to training provided by the employer and whether this is mandatory and or paid for. It's quite a tricky one, and certainly it's one that different employers are taking slightly different approaches to. But I mean, one thing I will say about this is that the written statement of main terms and conditions is a claim that can only be brought by someone where they are bringing a claim for anyone for something else. So say, for example, if someone is unfairly dismissed, so they bring their claim for unfair dismissal, they can also bring a claim then for the fact that they haven't got a compliant written statement of main terms and conditions. But unless they are bringing a claim for unfair dismissal or unlawful deduction for wages or some other kind of claim in the employment tribunal, they cannot bring a standalone claim for a failure to provide a written statement of main terms and conditions. So it isn't something really that, from a litigation point of view, that really causes too much difficulty. It's not something that comes up very often. And so even if there is a failure here, and I've got to say that there are still, because you've got to provide an up-to-date, even under current or previous legislation, you've got to provide an up-to-date written statement of main terms and conditions. And lots of employees don't have an up-to-date version. They might have a contract from 3 years ago or 4 years ago or even longer ago than that. Now, I'm not trying to downplay it. I'm not trying to suggest for a moment that you shouldn't be providing this information, because of course you should. It provides clarity in relation to contracts. Contracts of employment are a very important document. And certainly that's one thing that I would be emphasising if for those of you who do want to attend the post-termination restrictions webinar that will be running next week. Contracts of employment are very important, particularly where you're wanting to protect the business. But in terms of litigation, it's certainly not something that I would be losing sleep over. Contracts of employment are used in order to provide you with certainty, you the employer with certainty about how the employment relationship is managed and what entitlements people have. Holiday pay. Don't worry, we're very nearly there. Holiday pay. Right, so there have been a couple of changes in relation to holiday pay. The first change is in relation to the calculation of the holiday pay and the period of time, the reference period over which we calculate somebody's normal week's pay, their average week's pay. That's been changed from 12 weeks, which is what it was before, to 52 weeks. Now, personally, I see this as quite helpful for employers. I appreciate that it probably means that you're having to change your spreadsheets or your the systems that you're using, but it prevents the peaks and troughs. So where, for example, if you are operating in a business which is particularly busy in the run-up to Christmas, and so therefore people are taking a lot of overtime during the run-up to Christmas, and then of course they then have the Christmas holidays, then in those circumstances, with an average over 12 weeks, you are then going to be paying considerably more for the holiday during that period of time than you would be at any other time of the year. Whereas if the average is over 52 weeks, then that smooths out those peaks and troughs, prevents employees from actually targeting when to take their overtime for the purposes of then increasing the holiday pay that they then receive. And of course, the most recent change is this final bullet point, which is in direct response to the coronavirus situation that we've got at the moment, where I'm sure you probably read that there has been an extension to allow carryover of holiday for up to 2 years if someone is unable to take their holiday because of the coronavirus situation. Now, to my address, I can't really see this applying to too many organisations unless you are dealing with key workers, key frontline workers. So certainly the NHS is affected by this. Other public service organisations are affected by this, police and also care providers as well. And particularly for any organisation where they had their year end for holiday purposes, which may have been the 31st of March. The only carryover that is allowed is in relation to the 4-week Euro leave. So this doesn't apply to the full 5.6 weeks of UK statutory leave. Not really quite sure why, but it's only applied to the 4-week Euro leave. And it's only if somebody is unable to take their leave because of the coronavirus situation. So it's not a general freestanding right to carry over for up to 2 years. Okay. And then finally, well, not quite finally, but the final point is a very minor point indeed. Finally, data protection. So the ICO have published some draft guidance in relation to dealing with data subject access requests. This is quite a detailed document, as you can see, as most documents in relation to data protection tend to be. 77-page guidance document. Obviously, I haven't replicated the content of it here. It's only draft guidance at the moment. The consultation on the document has closed. When I send the slides out, you will have the link here in the document provided to you. So if you do want to go through it, then please do so. As you can see, these are the sorts of issues that it covers. You can read and see that there. And then finally, IR35. As I'm sure you read, the extension of IR35 has now been delayed until April 2021. I'm sure a lot of you were probably already had already put in train the measures that you needed to do so in order to be able to comply with the changes to IR35, but we now need not worry until April 2021. So that's just simply that is delayed. And that, everyone, that concludes our update. 2 minutes past 11, which actually for me actually goes to schedule, because I did say that the presentation itself would be an hour and then I would leave some time for Q&As. But so far, I don't know whether it's because I've covered absolutely everything in terms of every topic, but I don't have any further questions and answers to cover. Obviously, please do get in touch by email. We have an email update list. Also, please do keep an eye on LinkedIn as well. I don't put everything out on email because simply I'd be bombarding you with emails if I did so, but I do keep my LinkedIn profile all up to date. So I post updates on LinkedIn and also on Twitter as well. So please follow me on both of those if you want to see the less important things which perhaps I don't feel the need to email you on. So keep up to date on by that. And also, if you are interested in any of our support packages, then please get in touch with us. I'm very, very happy to give you information on that. And as I said, 29th of April is our post-termination restriction webinar, which we will be running then. I will send the details around to you by email, the login details. It should be quite a good and interesting session, that one. So if you are wanting to review your post-termination restrictions in your contracts, if you're concerned about the enforceability of them, or you're just concerned about recruiting people who might have them, then please do come along to that session. It would be great to see you there. But without any further ado, that concludes the session. So unless, oh, hang on a second, I just see that I've had a question come in. No, I haven't. I've just had a thank you. That's excellent. Thank you very much. So hope you found that useful. Great to see you all. And oh, I don't know quite what's happened. Oh, sorry, I don't know what happened there, but hopefully you can still hear me. Take care, everyone, and see you soon. Thank you very much.